On the last episode of Tennessee Court Talk, we learned about the purpose, history, and day-to-day inner workings of the Criminal Court of Appeals. On this episode, we are sitting down with 3 more of the 12 judges that make up Tennessee's Court of Criminal Appeals to discuss post-conviction relief. If you're listening to this and have no clue what I just said, then this episode is for you. We're breaking down what happens after a criminal conviction in Tennessee. The process usually starts with a direct appeal to the Tennessee Court of Criminal Appeals. On direct appeal, the focus isn't on retrying the case. Instead, appellate courts look at whether the trial judge made the correct legal rulings and whether any errors actually affected the outcome. They do this by reviewing the trial record, not by hearing new evidence. If a direct appeal doesn't work, the next option is post-conviction relief. This process is even more limited than a direct appeal. Within 1 year of the final order, a defendant can file a post-conviction petition in the trial court, usually raising issues that couldn't be addressed on direct appeal, like ineffective assistance of counsel. If that petition is denied, the defendant can then appeal to the Tennessee Court of Criminal Appeals. Joining me in today's discussion are 3 judges who know way more about this subject than myself. They are Judge John Campbell, Judge Tom Greenholtz, and Judge Stephen Sward. Gentlemen, welcome to Tennessee Court Talk.
Thanks, Nick, for having us.
All right, so let's just jump right into this. What role do post-conviction proceedings play in Tennessee's criminal justice system, and how are they different from a direct appeal or other ways of challenging a conviction after the case is over?
I guess the easiest way to consider it is that the post-conviction procedure is a way for a defendant, after his appeal is over with, to bring up what he considers to be errors, constitutional dimension, that were primarily caused by his attorney by not adequately representing him in the trial. That's what we most often see, and this is something he couldn't raise on appeal because it's all kind of comes out after the fact, and then he's allowed to present evidence to the court to try to establish that his lawyer just fell below the standard of care that you expect from attorneys, and because of that, he suffered some kind of prejudice. So that's what post-convictions is about. And then an appeal is basically all the errors that you claim the court committed during your trial that you say caused it to be, I don't want to say fraudulent, but suspect, and allows you to ask the court to reverse and send it back for a new trial or for other relief. So that's kind of the main difference.
And Nick, Judge Campbell brings out 2 really important aspects of post-conviction. One is that you can only deal with issues that could not have been addressed earlier. Otherwise, they've been waived. And the other thing he said is there of a constitutional nature. And so the statute that creates post-conviction relief limits it to those issues that were a violation of either the Tennessee Constitution or the Constitution for the United States.
Yeah, I think that's exactly right. I view post-conviction proceedings as kind of fundamentally a check in the system, right? So you have, all the due process rights that you have through trial. So you've got the right to a public trial, an impartial jury. You have the right to counsel. You have the right to have the state prove your guilt beyond a reasonable doubt. You have all of those kind of fundamental due process rights at a trial. When you take an appeal on direct appeal, you're challenging about whether there were errors in the trial. Was evidence improperly admitted? Were the procedures not up to snuff, so to speak? Here with post-conviction, though, it's after the conviction has been affirmed on appeal, and as my colleagues are saying, it really is limited to people coming into court saying, "Hey." Irrespective of what happened in my trial, the conviction was actually obtained in violation of the Constitution, and I need to have a hearing on that. And this is kind of a fundamental check on what happened at trial, making sure that that those important rights were followed and respected as it goes. And it's not often, candidly, and we'll talk about this, it's not often, candidly, that you'll see relief granted in post-conviction proceedings because the standard is a high standard necessarily. But where it is met, it functions as an essential check in the system.
Would you say it's just another way to get back into the appeals process, or is it completely different from that? Because if you've already lost on direct appeal, you wouldn't just jump right back into the appeals process without a reason, correct?
Yeah, it's not a substitute for appeal. I think as Judge Sword indicated a moment ago, the nature of the issues that are being raised in post-conviction are generally very different than the nature of the issues that were raised at trial. And in fact, if you could have raised an issue at trial and you didn't do so, post-conviction is not going to afford a remedy to you. If you tried to raise an issue at trial and it was decided against you and affirmed on appeal, for example, it's not a do-over. The law actually prohibits that, both issues that you could have raised and did not, and those that you did and were unsuccessful with it. So it's not a substitute in that way. And, as we've talked about, the statute itself, all of these proceedings are governed by a specific statute that the General Assembly enacted. All of these are limited to constitutional issues. And so we're not talking about, garden variety, evidence issues at trial or garden variety claims that a trial court should have acted in a certain way but didn't at the trial. These are most often we see the constitutional issue, as Judge Campbell indicated, most often the constitutional issue we see is a violation of the right to counsel, where a defendant comes back into court and says, typically, the Sixth Amendment guarantees me the effective assistance of counsel at my trial. My lawyer, so the claim would go, was ineffective, meaning that the representation that I received fell below the standard of care that an ordinary lawyer would have given under the circumstances. And that affected the outcome of my trial. That was prejudicial to me. So those are typically the claims that we see. There are other types of claims that arise, but those are the ones we typically see.
In fact, when you start talking about, as Judge Greenholtz says, if you start talking about on post-conviction, well, the court didn't charge the jury correctly, or the court ruled against my motion to suppress, the court, sentenced me wrong, or something like that. These are all issues that could have been or should have been raised on appeal, and so we wouldn't even consider those anyway. But if you say my lawyer was ineffective for not raising this issue or not making an objection when the court did this, well, then that gets you into the Sixth Amendment issue, and that would be something that would be reviewed on post-conviction. But it's extremely narrow, and the burden's on the petitioner to prove it by clear and convincing evidence, and he has to show that it really had an impact on his trial. So it's a very, as Judge Greenholtz said, very high burden, and it's the way the statute was kind of designed, so you don't have this constant, litigation about a final judgment. It's kind of supposed to be a one-time thing, and then it's over.
Your question really illustrates a common misconception by pro se defendants as well as the public, is that it's just another bite at the apple, another continued appeal. You get victims' family thinking once the appeal is done, the case is concluded, and then this other proceeding has started. It is not. It's completely separate and different than an appeal. It's an extraordinary statute that the legislature's committed, as Judge Greenholtz discussed, just to address a very narrow set of circumstances.
All of you are former trial judges, and from that perspective, what is the most common misunderstanding lawyers have about the purpose and limits of post-conviction relief?
The most common thing I see is this not understanding the proof, not understanding that you have a responsibility, if you're a petitioner's attorney, to prove your allegations. And we have a lot of people that come in and they'll make all kinds of allegations about, well, they didn't call these witnesses, they didn't do this, they didn't do that. But they don't ever really establish what difference it would have made had they called these people. I mean, the proof comes down to what they present to the court. And there seems to be, I think, a misunderstanding that if I make these allegations, then I put it on the state to have to rebut them. But not necessarily. Not if it's just allegations without any factual backup, then the court's pretty much left with no resort but to dismiss it because you haven't proven your case. And I think that to me is one thing that I see pretty regularly, is just a misunderstanding of the burden, and that it truly is the petitioner's burden to prove his allegations by clear and convincing evidence.
We were just talking about how a lot of people see post-conviction as just another appeal or second bite of the apple, and we'll quite often hear the same arguments that were made on appeal and in the trial court, and that's not the purpose. And The United States Supreme Court and the Tennessee Supreme Court follows the same standard. A petitioner to receive relief under a post-conviction petition must show not only did they have some constitutional right abridged, but they actually suffered some prejudice from that abridgment of the right. And so a lot of times we'll have attorneys who represent these defendants on petition of post-conviction relief. They'll get the first part and they'll argue, the trial lawyer should have done this or they should have done that. Like, for instance, a common one we see is they'll argue that the trial attorney should have called this witness that the defendant knew about who could have established an alibi for him. And so the defendant gets up there and says, my cousin Jenny was with me that whole night, and she could have, if my attorney had called her, she would have said it couldn't have been him, he was there. But guess what the post-conviction lawyer doesn't do? He doesn't put cousin Jenny on the stand. And so how do we know that the petitioner was prejudiced by this unless we hear cousin Jenny say, yeah, this is what I would have said had he called me? And so that's one of the big failures that we see, is that inability or misunderstanding that you have to show that you were prejudiced by the constitutional violation.
Yeah, I think from my perspective, both Judge Sword and Judge Campbell are exactly right. What I would typically see in the trial court was a lawyer would come in and representing a post-conviction petitioner and complain bitterly about the representation that the original trial counsel rendered. Effectively to say, I wouldn't have represented the defendant this way, and I just can't imagine anyone else would have. And we really need to take a look at this. They'd be talking about all the things that the original trial counsel did wrong without realizing two things in particular. One, as what Judge Campbell and Judge Sword have said, you're going to have to show that whatever you think happened, that the original lawyer didn't do well, you're going to have to show that that affected the outcome of the trial. And most of the time, they're not talking about that. They're just talking about complaining about the deficiency. Two, they're not realizing that the original trial counsel gives representation in a lot of different ways, under lots of different strategies, under lots of different, trying to look forward to see what will influence maybe the verdict of the jury. Maybe I'm not making an objection on purpose because I don't want to highlight particular evidence before the jury, or maybe I'm not calling a particular witness because I've talked with the witness ahead of time and I don't think that witness is going to help at all. And so a lot of times in the post-conviction context, we're not talking about, hey, it does seem a little strange maybe that the original lawyer didn't pursue this particular course. But in post-conviction, we're not realizing that, yeah, maybe there was a strategy for that. If there was a strategy, typically the courts and the Constitution will defer to that original trial lawyer. You're entitled to a fair trial, not to a perfect trial. And the original trial counsel has the right to make strategic decisions in that litigation, even if it turns out that it was a call that didn't help. Typically, we're going to defer to those strategic calls by counsel. So those are the things that typically I would see in addition to what the other judges have noted.
Okay, so you say that they have to show how it actually altered the trial. What are some more grounded examples of that? So like, instead of just saying, oh, well, my lawyer, didn't do a good job and didn't represent me well anybody can go up to a judge and say that they lost. Of course they think that my lawyer was ineffective.
Well, you could think about it maybe one way, and I don't mean to jump in over you, but you could think about it one way pretty clearly. Let's say that that scientific evidence is admitted at the trial. Let's say that I've got maybe a fingerprint expert that's coming in. And if it can be shown, for example, that had the defendant called a fingerprint expert and had that expert testified and had really put the doubt to the state's evidence, that may have affected the verdict at that point. Let's say, particularly if the fingerprints were maybe kind of the evidence that were tying the defendant to the crime, calling that fingerprint expert at the trial may have resulted, depending on how it goes, may certainly have resulted in a different analysis. But look at what you'd have to do in the post-conviction context, though. It's not enough simply for the defendant to come in and to say, hey, my original trial lawyer should have called an expert. At the post-conviction proceeding, you've got the obligation and the burden to call the expert yourself, now in post-conviction. to show, as Judge Sword said a moment ago, to show what that testimony would have been had it been offered at trial, so that the courts then can make an analysis about how that new evidence would have affected the outcome.
Just building on this, how can you show that a lawyer fell below the standard and that would have had an impact? Well, one of the things we look at on the trial judge needs to look at, and what we look at when we evaluate these things, is what first of all, the law is clear. We're not supposed to be a Monday morning quarterback and, substitute our judgment for the lawyer at the time. But one thing we do have to look for is how well prepared was a lawyer. If the lawyer is well prepared and makes strategic decisions, then we're not really supposed to second guess him. But the situation might come down to is the lawyer's not well prepared. The testimony establishes that he didn't talk to the witnesses ahead of time. He didn't really consider a suppression issue that looks like it may have had some merit. That gets you in the door where, if you can establish, if the petitioner establishes that his attorney wasn't well prepared, then his strategic decisions all of a sudden don't carry a whole lot of weight. And, that's what the proof is supposed to establish. And doesn't happen often, but every now and then you'll get a case where it doesn't look like the lawyer really got prepared. He got a few things together and talked to a couple people, but didn't really didn't really maybe listen to the client and look at other avenues that maybe were available that can be proven, maybe can be brought in post-conviction, show, hey, I would have testified, this is what I would have said. Then you may get relief, but it's and those are the things we see. And we see every now and then, we'll see one where you clearly are going to say the lawyer was not prepared and you're not going to give him that deference on his strategic decisions. But it can happen, and that's what we're talking about, as opposed to just throwing out a bunch of, well, I wish he should have done this or should have done that. If you come with the receipts, then it's a whole different animal.
Can post-conviction relief, does it have to be from someone that is incarcerated, or can it be someone who just simply got their license taken away from too many DUIs? Or
to answer your question, no, you don't have to be in custody. And I've had post-conviction cases where the defendant was sitting right there in the audience, was not in custody. It just has to be filed within a year of the final judgment. And if they're, and if you have a misdemeanor case, if you're on probation, I mean, technically you can still file a post-conviction, and we've seen that. But but you don't have to be in custody. You have to be, like for habeas, you have to, but for post-conviction, you do not have to be in custody in order to file. In order to be, you could be out. You could be out and still pursue it. So there's no requirement that you be in custody.
Can you explain habeas just for a second for
habeas
our
corpus?
Audience?
Bring the body means you're being unlawfully detained, and the habeas corpus is to bring the body. It's the oldest writ around, and bring the body to court and let them establish that they're being held illegally, and then the relief is to release them from custody. But that's a whole nother animal, and it's even narrower than post-conviction. It's a very narrow in Tennessee remedy. So we see them quite a bit, but they're very rarely successful.
All right. So what types of proof tend to be most persuasive or least persuasive at a post-conviction evidentiary hearing?
Usually when you're in a post-conviction proceeding, you're probably talking about the effective assistance of counsel. And so it's very important to hear from two people in that case. One is the defendant, the petitioner, who he's actually required to testify if he has personal knowledge of the facts he's alleging. And the other is the trial counsel who represented them. And so you might think, well, the judge is just going to automatically believe what the lawyer says. But in my experience, that isn't necessarily true. What I have found quite often is the petitioners, the defendants, have a much better memory of what happened because that was their lives. And for the trial lawyer, it was one of 20 cases he was handling that month. And what is effective, when I was on the trial bench, what was really effective to me is when trial counsel testified and they had documentation in their file. Like, no, I met with him 10 times to discuss this. And they could tell you the dates they met with him and tell them the topics. They would reduce those meetings to writing and send a copy to their client. That was always very persuasive to me because it showed that the lawyer was doing their due diligence in representing that client. But the lawyers who come in and they're like, I may have met with him. I usually do. This is what I usually say. I can't remember having that conversation. That was never very persuasive to me as a trial judge.
I think I had the kind of the exact same reaction. I can remember one post-conviction hearing in particular where the petitioner's counsel was truly outstanding. And it was outstanding because not only did the petitioner testify, as he did in that proceeding, but the lawyer brought in a lot of corroboration. So, for example, when the petitioner testified, I only met with my lawyer twice at the jail, and we didn't discuss these important topics that I think now we should have discussed. The lawyer brought in the jail records where the lawyer would sign in, or in that case had not signed in. And just as Judge Sword is saying, when the trial counsel was on the stand, there was nothing really to rebut it. The trial counsel didn't have good recollection of what it was because counsel didn't maintain the records in her file. As it goes. And so where you have not just testimony from someone who's been convicted maybe of a serious crime, but then you've got corroboration of what is being said at that point. I think that's the real trick with the lawyer representing a post-conviction petitioner, is not just to put the client up on the stand and have them testify as to what they think should have happened or did not happen. That's very important. But to help reinforce the credibility of that testimony, as Judge Campbell said a moment ago, I think he's exactly right. Bring the receipts, and then have a very careful, structured, prepared examination of trial counsel in that case, just knowing where the burdens are. In my experience, that was the most effective.
Well, you're going to have conflicting testimony in these things, right? So is that the only way to evaluate the credibility for post-conviction hearings?
Well, and I'll tell you, sometimes you really don't have a lot. There's not a lot of disagreement. I mean, that's the thing that's interesting about when you talk about criminal cases. A lot of times when you talk about, there's only a little bit of in the case that's disputed when you really get right down to it. And, they'll say, well, yeah, he met with me X number of times. And this goes back to the prejudice. Well, he didn't meet with me enough. What difference would it have made if he met with you more? I mean, what are you saying you didn't discuss? What did you not understand? So, that's where you got to show prejudice. But it's always better when the lawyer is prepared. It makes it so much nicer. I mean, it really does as a fact finder, because this is one of the few times we can be fact finders where the trial court actually it makes binding credibility decisions. It makes decisions that the appellate court has to adhere to based on our findings of fact, based on what we find of the witnesses. So, we want as much information as we can. But again, when you start assessing credibility, how logical and does their story sound? I mean, if it's just, oh, my lawyer never talked to me about anything, and the lawyer comes in, sometimes they'll have a memo where they wrote a memo to the defendant saying, okay, here's the offer, here's what, and go through all this stuff. I mean, those kind of things just make the court's job so much easier. When there is no documentation, then you really have to kind of listen, okay, who sounds more reasonable, and what other evidence corroborates it outside of, because, we can rely on the trial record too. We look and see what happened at trial. And when lawyers make objections that the defendant is claiming were not discussed, yet they were made on the record, yet they were pursued by trial counsel, makes it look a little less likely that this wasn't discussed with the defendant, or at least wasn't made aware at the time it was being done. So it's not really a he said, she said all the time. There's usually a lot of other little factors that the trial court's required to analyze. And that, you have a whole record, you have all the motions that were filed, you have all that gets taken into account when you start assessing attorney performance.
I'll probably add to that. One of the frustrating things as a trial judge is dealing with these PCRs. 9 out of 10 of them quite often are just the petitioner having no other remedy, so he's just looking for something to raise. And sometimes their attorneys treat it that way, and sometimes the district attorneys do too. And in PCRs, post-conviction relief, the state is represented by the district attorney, not the attorney general reporter like in a habeas corpus proceeding. And a lot of times the DAs will not really do their due diligence and look at the record from the trial. They'll just put the trial attorney on there instead of helping the trial attorney prepare for the hearing and say, well, your client, former client, is alleging that you never went to the jail and met with him. Do you have any documentation from the jail? Or let me call the sheriff and see, hey, I saw that this particular defendant met with his attorney 4 different times. And so sometimes you'll see the state really sort of try to coast through it without doing their own due diligence.
So what should practitioners understand about the trial court's role as fact finder in post-conviction hearings, particularly regarding credibility determinations?
Well, give them facts to find. I mean, I think that's the thing that really aggravates, at least when I was a trial judge, is that, you don't close the deal. You don't go in there and actually establish your fact. You allege it, you shoot all around it, but you don't ever hit it. And I think that it's I think a failure to understand that you have to go that extra mile in order to prove your case. I mean, as a prosecutor, we had to, that you have to close the deal with the jury as far as proof. You have to establish the elements of the offense. In post-conviction, you have to establish, if you're a petitioner's attorney, there's 2 things you have to establish: that the lawyer fell below the standard of care of a typical attorney in that area, and B, that it had a prejudicial impact on the case. And that's what you got to prove. And if you just kind of throw up about a bunch of allegations, you're never going to prove it. And more often than not, that's what we wind up seeing. We see a lot of talking, but we don't see any actual hard evidence to support it.
And Nick, I know you're talking about practitioners from the perspective of the attorneys, but thinking about the trial judge, the post-conviction judge who's hearing it too, one of the errors that I really struggled with early on in my career as a trial judge is I would write my findings of fact the way an appellate court would. I would just sort of recite what the witnesses had said. And what the appellate courts need the trial judge to do, and the post-conviction judge, is actually make decisions on what the truth is. What do you really find to be the fact in the case? And so, as Judge Campbell was saying, the practitioners have to present to the post-conviction judge facts to decide on. Well, the trial judge, the post-conviction judge, has to decide on those facts and lay out, here's what I believe really happened. Here's what I find to be credible. And this is what I think the facts were in this particular situation.
I think it's kind of interesting here from the practitioner's perspective. Post-conviction proceedings are unique in the criminal law. So those of us who had practiced maybe criminal defense kind of regularly, and then are assigned maybe a post-conviction case, maybe by way of appointment, or the family comes in and wants to retain you for a post-conviction proceeding. Yeah, Judge Campbell really kind of hit it. It's not the same. So I think for criminal defense practitioners, maybe sometimes we get used to maybe just poking holes in the state's evidence. Maybe we prepare for cross-examination of witnesses and try to make a flash here or there, and with the aim of just trying to raise reasonable doubt as it goes. That's not the case with post-conviction. As Judge Campbell says, Judge Short has also said, it's a completely different animal. Now the burden's on you. Now the burden is on you to go get the evidence. Now the burden is on you to establish that there was deficient performance and that there was prejudice, that it affected the outcome of the trial. And that requires preparation. It requires knowing what the law is. I think, at least in my experience, sometimes post-conviction practitioners maybe have not even read the statute, but certainly are not familiar with the cases. And at least a quarter of the cases I author are going to be post-conviction cases. That's a pretty high percentage, frankly. They're not reading the cases. They're not aware of the standards as they go. And then consequently, when they get into a hearing, they may not actually know what they need to be offering. The expert issue that I brought up earlier, I think some post-conviction practitioners would be surprised to know that if they're complaining that trial counsel didn't call an expert at trial, that they have the burden now of calling that expert at the post-conviction hearing, which means before the hearing, you have to locate the expert. Before the hearing, you're going to have to get an opinion from that expert, and then you're going to have to argue persuasively at the post-conviction hearing that had that been offered at the original trial, the result would have been different. I cannot emphasize enough from the practitioner's perspective how different post-conviction proceedings are from regular criminal defense proceedings. and how you really need to be prepared and to understand these before you handle them. And I think when you do that, it certainly helps out the judge. It helps out the proceedings in their entirety, certainly.
That concludes part 1 of our conversation about post-conviction in the Criminal Court of Appeals. All Tennessee Court Talk episodes can be found at tncourts.gov.